is the shortest that I've ever experienced. The pertinent dates go this way. On July the 6th of 2021, the sellers, who are the plaintiffs in this case, contract with the buyers, who are the defendants and who I represent, Raj Patel and Graciela Lobos, who are the joint buyers of this, enter into the sale of a residential piece of real estate. It was a traditional real estate agreement, the one that you can go to Lowe's or Home Depot and buy a copy of, your traditional real estate PSA form. That was entered into on July the 6th of 2021. There was a earnest money deadline. It was a traditional $5,000 of earnest money was to be deposited after 5 days. All parties are admittance that that deadline was not met. As a result to that, we resort to standard language within the real estate agreement that provides that if the earnest money is not paid within the 5 days per the contract, then upon notice of the sellers, the buyer will have 1 day to complete the earnest money transaction. And the record will reflect that that letter was sent on July the 15th of 2021, giving a 5 p.m. deadline on the following day, July the 16th, in order to pay the earnest money. After that, Raj Patel, who I represent, one of the buyers, went to First Horizon Bank and initiated the earnest money deposit. Now, the important thing about the contract to note is that the earnest money was to be paid to the holder, and the holder was designated within the PSA to be Coldwell Banker Wallace, the real estate company. Coldwell Banker Wallace utilized something called Deposit Link in order to initiate a wire transfer of earnest money. And the record will show, and a copy of it's been provided, I believe it's on page 11 of the brief, that there was a earnest money deposit made through that Deposit Link software that was completed and accepted by the holder, who was Coldwell Banker Wallace. And that was done before the 5 p.m. cutoff that had been provided by the sellers in this, pursuant to the PSA. That evening, at about 7 or 8 p.m., the sellers canceled the contract. They sent another standardized form in residential real estate called a RF 656 and stated that they didn't believe that the money that had been paid to Coldwell Banker Wallace was paid in immediately available funds. And based upon that, they sent notice canceling the real estate contract. Suit was subsequently filed by the sellers on July the 19th of 2021. And on July the 21st of 2021, after the suit was filed, the payment of the earnest money was reversed because Mr. Patel, upon receiving notice of the cancellation, withdrew the funds to reverse the wire transfer. Now, we're here because a motion for summary judgment was filed at the trial court level by the sellers, stating that because the earnest money was not paid in quote, immediately available funds, and instead was just paid by preference of the earnest money holder, Coldwell Banker Wallace, that constituted a material breach of the contract. That motion for summary judgment was opposed by Mr. Patel, and at that time, Ms. Lobos was represented by a different counsel, Brian Mansfield out of Sevierville. I represent both on appeal. And our argument is that the trial court erred in granting that motion for summary judgment because the trial court found that the earnest money was not appropriately paid within the 24-hour saving period as set forth in the PSA. And that was a fact that we vehemently denied through the submission of discovery, through our answers in the motion for summary judgment, in their proposed fact, we had explained that we indeed did comply by providing that earnest money deposit as instructed by the holder, who was Coldwell Banker Wallace. And that is not the determination of the seller to decide whether or not the earnest money was paid or not, because the actual holder of the earnest money is the one that makes that determination, and our client complied with the instruction of Coldwell Banker Wallace in doing so. Indeed, in the motion for summary judgment, evidence was submitted that attorneys for Coldwell Banker and Wallace thought that the cancellation form sent by the sellers was improper because they were under a binding contract as a result of sending the earnest money through the deposit link during that period of time.
Was there any testimony or affidavits by Coldwell Banker confirming that the earnest money was cleared with them?
Not from Coldwell Banker directly, Your Honor. It was only the receipts from Coldwell Banker that had been submitted from the parties. Moving on, Your Honor, we also took issue with the actual order granting motion for summary judgment. That was wholly non-compliant with Rule 56. No legal reasoning in it. There's no discussion of the factual issues, and it looks to be just a wholesale adoption of the plaintiff's position without any appropriate legal reasoning. After the motion for summary judgment was granted, a damages hearing was set. There was one singular witness at the damaging hearing. It was only the husband of the spouses that were selling. During that, he provided absolutely no testimony as to the valuation of the home at the time of the alleged brief. There was testimony that several months later the home was sold at a lesser value, and here the sales price was $695 and the eventual sale was for $650. But absolutely nothing about the market value of the home at the time of the apparent breach was adduced, which would be the appropriate way to measure damages when we're talking about the violation of a real estate contract. But the evidence just lacking at that. And then lastly, there was an argument about attorney's fees. This case was a little particular because the plaintiff's lawyer was also the plaintiff's brother. When he submitted attorney's fees, he submitted a flat fee of $15,000 to the court. Again, the damages that he asked for in the difference in valuation was $45,000, the $15,000 sounding an awful lot like a contingency fee. There was no itemization that was submitted. There was no discussion of the work involved. There was no discussion of the hourly wage. None of that, none of the normal lodestar factors that this court regularly determines in considering the reasonableness of an attorney fee was actually submitted to the court, nor did the court ask about or discuss them. When the brother, who is the plaintiff, was on the stand discussing the attorney's fees, he was asked if he actually paid the $15,000. And he said, no, I paid something, but I don't know what. He couldn't remember. He couldn't produce a receipt of actual fees paid. So lastly, Your Honors, we argued that the award of $15,000 of attorney's fees on this residential real estate contract breach with no itemization of the time spent.
Was this contested in the trial court?
It was.
Okay. And was there any impeachment to the testimony?
Yes, we specifically asked whether or not he'd produced anything or whether or not he'd actually paid any of these fees.
Was there any testimony contrary as to what a reasonable fee would be?
There was no contrary testimony as to a reasonable fee, but there was argument before the court that none of the evidence regarding the lodestar factors that we regularly determine were actually considered or any proof thereof presented. And Your Honor, if there's any questions, I'm happy to field them regarding these real estate contracts.
Yeah, let me ask you, what was the state then of this contract after the earnest money was purportedly paid, and then the seller apparently sent a notice of cancellation? What's the status of that real estate contract at that point?
The status of the contract at the point that the earnest money was paid was we had a binding real estate contract. The seller had sent a notice, but the notice to withdraw was based upon what we state is an erroneous assertion that the earnest money had not been paid. It's our status that at that point in time, that was a binding real estate contract, and that there was attempt to schedule a home inspection afterwards to go forward with the contract, but the seller refused to do so, instead 3 days later filing the lawsuit in the Chancery Court.
So your client was prepared to go forward on that contract?
Yes,
You didn't sue for specific performance?
we did not sue for specific performance.
And what do you say, let's assume your client did in fact breach. What do you say the measure of damages are?
The measure of damage would be the value of that real estate property on July 6th of 2021 when the RFA was entered into.
Was there any testimony at trial about value
None,
at
Your
the time
Honor.
of the contract?
None, Your Honor.
So the only proof was what it was sold for later
Correct.
versus what you had offered,
Correct.
which was $45,000 or $50,000 more.
$45,000 more, Your Honor.
No other questions, I hear none. Was there anything else that you want to present in your argument?
No, Your Honor. Again, we just reiterate that the motion for summary judgment should not have been granted with the disputed facts that are involved in this. And we ask for a remand to trial court so that we can have, again, he asked for a jury trial on this, and the jury is the one who should be determining these issues, not Chancellor Pridemore in the specific case.
Specifically, how were those facts disputed? Affidavit, deposition?
They were disputed through sworn interrogatory that was submitted in response to the motion for summary judgment.
Okay. Thank you very much for your presentation. This case now has been submitted to the Tennessee Court of Appeals. You should receive our opinion and our order within a reasonable period of time. Thank you very much.
Thank you, Your Honor.